barely fit. Good afternoon. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. Welcome to our monthly program for the month of November, part of a monthly series that we do and have been doing for almost 5 years now on a wide variety of various nonprofit legal issues. Today's topic, for those of you who have been regular attendees and followers of our monthly series, you'll notice that we at least once a year, often twice a year, will cover various employment law topics and human resource topics. Not because there's always something particularly unique to nonprofits, although sometimes there certainly is, and we've covered a number of those and covered aspects of a lot of these rules and statutes that are unique to nonprofits, but because regardless of whether you're a nonprofit or a for-profit employer, these are some of the most challenging, vexing, difficult, and from a lawyer's perspective, interesting issues that we deal with on the compliance front. They're issues that we constantly get questions about. These are issues that you guys are constantly struggling with, and judging by the turnout for today's program, we have a full house here in our DC office, and we have about 350 people signed up and participating across the country today by webinar. It's clearly a hot topic. And today's topic is obviously spurred in part by the U.S. Department of Labor's proposed rules with regard to what's called the salary basis test, test that we're going to get into very shortly in today's program. But that's only one change in part of a broader set of rules governing exempt versus non-exempt employees. This is an issue that has tremendous implications for all nonprofit employers. It's a very complicated, very difficult issue to get your arms around. It's even more difficult to administer within your own organizations. I don't think we, and I'll say this on behalf of Todd and Jennifer, and my colleague Doug Mishkin and other employment lawyers here at Venable, I don't think we've ever talked to or gone and seen a nonprofit client of ours where when we look at their classifications, who's classified as exempt versus non-exempt, that there were not, in our judgment, some, if not many, mistaken classifications. This has really serious potential adverse consequences for your organizations at multiple levels that we're going to talk about. And as a result, it's part of the reason why today's topic is so interesting. We did pack a lot of material. Those of you in the room have a handout booklet that has the PowerPoint slides. You'll see there are quite a few slides in the PowerPoint deck. Those of you in the webinar, the confirmation email that you received this morning had a link to those slides. By definition, with the 90 minutes that we have allotted, we're not going to be able to get through all of the slides. We're going to focus on those that we deem are the most important, but we wanted you to have the full slide deck as a resource. We're going to talk about exempt versus non-exempt classifications. We're certainly going to talk about the DOL's proposed rule in this area, but we're also going to talk about related issues which tend to be incredibly important. Things like, for non-exempt employees, what is compensable time and what is not? Can comp time be used with non-exempt employees? Things like this we're going to try to cover in today's program as well. A few housekeeping things before we get into the heart of the program. For those of you from the Trade and Professional Association community, these programs are eligible for CAE, Continuing Legal Education Credit. As I said earlier, this program is part of this monthly series that we do on different nonprofit legal topics. I wanted to give you a preview of the programs we have scheduled. We actually have 5 scheduled. I haven't come up with a title yet for the April one. But on December 10th, our program is entitled A Breach Can Happen to You or Already Has and You Just Don't Know It Yet, How Nonprofits Can Best Manage Cybersecurity Risk. January 14th of next year, our first program of 2016 is a program that I'm particularly excited about. It's a program that we're going to be co-sponsoring with the Inside NGO organization. And we have 2 terrific speakers from outside Venable coming in to join me for that program. The program is entitled Impact Investing in Nonprofits, Opportunities, Innovative Structures, and Creative New Ways to Raise Funds and Further Your Mission. For any 501c3 organizations participating in today's program, or even if you're from, say, a 501c6 or C4 organization that has a 501c3 affiliate, this is a program that you're not going to want to miss. February 4th, our topic is entitled Nonprofit Chapters and Affiliates, Finding Structures and Relationships that Address Your Challenges and Work Well for Everyone. And finally, on March 10th, at least once a year now, we have to devote one of our programs to the issues involving nonprofit federal award recipients of federal grants, cooperative agreements, and contracts. It's such a complex area these days. There's so many compliance obligations on recipients of and even the smallest amount of federal funds. Our program on March 10th is entitled Nonprofit Federal Award Recipients Meeting New Requirements, Avoiding Dangerous Pitfalls, and Adding Value Through a Strong Compliance Program. And then, as I said, in April, I think it's April 14th, our program is going to be focused on some hot-button unrelated business income issues for nonprofit tax-exempt organizations. I mentioned that you have a handout book in front of you, those of you here in the room, that has the PowerPoint slides. That also has full speaker bios and some articles of ours on this topic and related topics that should be of interest, including an article that we wrote on the DOL's proposed rules that we put out a month or two ago. Those of you on the webinar will receive, all of you will receive an email tomorrow that contains a link to the recording of today's program along with the PowerPoints and all of the handout materials. All of the recordings of our monthly series are posted on our nonprofit YouTube channel where we have recordings of all of those webinars. The link to that is on the last slide of today's PowerPoint presentation. Because we're short on time, I'm not going to go through full bios of our speakers, but I will introduce them. To my far right is Todd Horn. Todd is a partner at Venable. He's been with Venable for a while now. Is an absolutely tremendous employment lawyer, works extensively with our nonprofit clients and for-profit employers as well. I noted that he was named Maryland's Lawyer of the Year for Employment Law in 2011 by Best Lawyers in America. He is widely respected and admired by many of our clients with whom he works with. It's a pleasure to always work with Todd, and I'm really glad he was willing to do our program here today. And then to my immediate right is Jennifer Przinski. Jennifer is an associate at Venable, also part of our employment practice, of course, who works very extensively, maybe almost exclusively these days, with our nonprofit clients. She's also a terrific lawyer, and you're going to learn a lot from both of them here today. So without any further ado, I'll turn it over to Todd to get us started. Todd.
Thank you, Jeff. How is everybody? Good, good. Fine, fine. Well, at 2 o'clock, when we're wrapping up, I suspect that some of you will come up to me and say, Todd, I'm not fine, okay? As a result of what Jennifer and Jeff and you just told me, I'm about as far from fine as I've been in a long time. You just told us about this 77-year-old dude called the FLSA who's about to get a bionic implant from the Department of Labor and then come after us. So no, I'm not fine. I'm concerned. Well, ladies and gentlemen, fear is good, okay? Fear causes you to be aware of risks and take steps to avoid those risks. So we're not trying to scare you. We're trying to comfort you indirectly. So let's start the comforting. The FLSA, 77 years old, it was enacted in 1938 after the Great Depression, and it generally regulates overtime, minimum wage, child labor, equal pay. If we had a full day, I could just list the topics. And when Congress passed the law, and it's not an enormous law, it's maybe 50 so pages or so, they went to the Department of Labor and they said, we want you to tell us what we meant. So the Department of Labor created regulations which span hundreds of pages and go into excruciating detail about what the law means. Every so often, the Department of Labor looks at its regulations and decides to update them or change them. And it's been about 10 years since there's been a major overhaul over the regulations. And now we have a brand new pending set of regulations coming. And Jennifer will go into detail about them, but the goal from the Department of Labor is to cover millions and millions of more workers under the overtime provision. So they're changing the law to make more folks covered and easier to get overtime. So now is a good time to refresh ourselves about some of the primary issues that nonprofits and others face as a result of the changes. And the first slide goes through some of the topics we will cover. from a higher standpoint, we're going to try to answer today 3 questions: 1 why and 2 what's. And the first why is kind of why are we here? Why are wage and hour lawsuits so prevalent? And they are prevalent. In the federal, I'm not going to bore you with statistics, but oh, by the way, did you know that 77% of statistics are made up on the spot? In any event, in federal civil lawsuits, a large component is employment disputes, about 25%. And within that, the fastest growing aspect is wage and hour lawsuits, and they have doubled over the last 10 years. And they haven't doubled like from 100 to 200. They've doubled from about 5,000 to over 10,000. And state laws are getting in the action too. They've had a similar growth. And the question is, why is there so much litigation? Well, the short answer is money, okay? There are enormous payoffs to employees and their lawyers who successfully sue companies and nonprofits under this law. If the employee wins, he or she gets unpaid wages. It is potentially doubled in most cases. They get to go back 3 years, and if they win, you not only have to pay your lawyer, you have to pay their lawyer. They're usually brought as class actions where employees band together and bring the same claim, and that has tremendous leverage on the litigation and balloons damages really quickly. Let me give you just a simple example. Let's say you have 50 employees who earn $15 an hour, and they say, you know, every week we work about 2 hours on our cell phones answering emails after hours or on weekends. If those employees successfully sue, going back 3 years, the liability can be over $700,000 plus attorney's fees. And if you're in a state like Maryland that allows triple damages, you're over $1 million right away. So you can see the motivation that lawyers have to bring these cases. In fact, plaintiffs' attorneys have begun targeting your employees with very slick television ads that are specifically designed for overtime, to get overtime claims. Another reason we see a lot of them is that these cases are often decided by a jury. Okay? What is a jury? A jury is a bunch of folks who do not like their employers and therefore will not like you and will like your employees and will do what they can to help you write them a check. As Jeff said, wage and hour compliance is very complex. The law and the regulations are extremely detailed, and a lot of times they're not founded in common sense. They're hyper-technical. And for those nonprofits who operate in multiple states, you also have state law wage and hour issues that you have to deal with. Okay, so that's the why. Now let's get to the meat of it and talk about the what. So before, I want to turn this over to Jennifer, who's going to begin telling you what are some of the main wage and hour obligations for nonprofits and some steps you can take to minimize the risk.
Hello, how are you? So close to the mic. Better? Oh yes, there we go. Okay. All right, so let's get to one of the reasons why we're here, right? Let's talk about these proposed regulations to the Fair Labor Standards Act. So in July of this year, the DOL proposed huge changes to the existing Fair Labor Standards Act. The DOL went ahead and invited comments, and that comment period ended on September 4th of this year. The DOL received 270,000 comments from people and organizations with regard to these proposed changes. That's 3 more times the amount of comments that they received the last time these regs were revised back in 2004. So if these regs are actually implemented, they're going to have huge impact on employers, including nonprofit employers. And these changes, as Todd had indicated earlier, are aimed at broadening the amount of employees eligible for overtime. So the DOL is estimating that the number of employees who are considered exempt from the Fair Labor Standards Act will decrease by 50%. So half of the exempt employees are going to be gone. They're going to become non-exempt. And that is going to make over 5 million people who are not currently eligible for overtime. So that is going to result in huge labor costs. So what do these regulations actually propose? So I'd like to break it down for you. So the main component that everybody's been talking about is this doubling the existing salary requirement. Under the current regulations, to be exempt under the Fair Labor Standards Act, you have to meet the salary requirement, which is $455 a week. And that's a salary of $23,660 a year. And I'm going to apologize for all the numbers right now, but there's a lot. So under the proposed regulations, the employee is going to have to make $970 per week, and that's a salary of $50,440 a year. So what does that mean in reality? Everybody who currently makes under $50,440 a year who is exempt is automatically going to become non-exempt and eligible for overtime. So how did the DOL arrive at this figure? The DOL is estimating that when the regulations go into effect in 2016, that figure represents the 40th percentile of full-time salaried employees. And why is the DOL saying we need this change? Well, they're telling us, well, there's too much lag time in between the rulemakings. And as Todd had indicated earlier, it's been 10 years, so it's gone a little stale. So they're saying this salary requirement and the extent of it is necessary to up the standard to today's living. So the regulations also propose an implementation of a mechanism that is going to automatically update the salary on a yearly basis. So not only are you going to start with your $50,440, every year after that it may be automatically updated. Now how are they going to arrive at that automatic update figure? They haven't decided yet. They're either going to use a fixed percentile wage or they're looking at the consumer price index, and they feel the DOL has indicated that these are going to take into various economic factors that affect wages like inflation or the like. So the last and final proposal is they're proposing an increase in the salary threshold of highly compensated employees. So under the current regulations, an employee is going to be exempt if they meet the duties test, but if they make an annual compensation of $100,000 a year. The proposed regulations are proposing that rate be raised to $122,148 per year. And that is going to be, that represents, they arrived at that figure, that's supposedly the 90th percentile of full-time salaried employees in 2016.
So Jennifer, I can stop, just make sure everyone's on the same page. Can you explain that a little more, how that kind of salary threshold for highly compensated employees, how does that work or what does that mean?
Okay, sure. So this is one of the highly compensated employees is one of the exemptions under the Fair Labor Standards Act. I'm going to get to that in a little bit, but essentially what happens is the employee needs to make currently needs to make at least $100,000 per year, and then they have to meet one of the other duties that one of the other exemptions perform, which is the executive, professional, administrative, which is I'm going to go into in a little bit.
But how does that differ from a salaried employee who makes $75,000 a year and meets one of the duties tests?
Well, the duties test is a little more limited with regard to the highly compensated employee. The highly compensated employee only needs to meet one of the duties tests. We're going to go through and talk about the administrative exemption, the professional exemption, and the other exemptions, and there's several different components to those duties, whereas the highly compensated employee only needs to meet one of those. But the important thing that there's no change to that portion of the duties test for highly compensated employees. They're just raising that threshold approximately $23,000.
Okay, so just to recap, make sure this is complicated stuff and before we get even more in the weeds. So in order to be exempt from the overtime provisions of the Fair Labor Standards Act, you have to meet a minimum salary, which is about to double if these rules take effect, and you have to meet one of the duties tests. And if you don't meet either one of those, then you don't qualify for the exemption from overtime. But if you're, in addition to that, if you're a highly compensated employee, you also have to meet that highly compensated salary threshold, which is also going to go up. and you have to meet one of the duties tests, but the duties test is less. It's less difficult to meet for a highly compensated employee. Okay, thanks.
Correct. And so the proposed regulations also do not propose changes to the duties test, which Jeff and I were just talking about. That's interesting. No proposed changes, but they do request comments on very specific areas. I'm going to get to that in a little bit. So let's go into the basics of overtime. All right.
Yeah, question?
I thought you were saying that when they were increasing the salary requirement to the $50,000 for 5440, that you did not also need to meet one of the exemption categories, that it was automatic.
No, there's always a duties test.
Okay.
It's just that the duties test for highly compensated employees is less difficult to meet and less burdensome than the duties test for the ones who meet the lower salary requirement. But you always have to meet both the salary test and the duties test.
Okay, thank you.
Yes. So the basics of the overtime, the general rule is an employer that's engaged in interstate commerce has to pay their non-exempt employees, those employees who aren't exempt from the Fair Labor Standards Act, a minimum wage and overtime for hours worked in excess of 40 in a work week, right? So, and that exercise, and they are paid at 1.5 times their regular rate of pay for any hours over 40 in that work week. So the overtime rules are going to apply if the employee is not exempt from the FLSA. So if I said it another way, that means exempt employees aren't entitled to overtime. And so some of the common exemptions that employees were able to categorize employees under so that they're exempt from the Fair Labor Standards Act are the executive exemption, the administrative exemption, the professional exemption, the computer professional exemption, the highly compensated employee exemption, which we were discussing earlier. And as Jeff had said, and your question was right on point, in order to meet one of these exemptions, there's two components. You have the salary requirement, and then you also have the duties requirement. And you have to meet both, or you're not going to make the exemption. So the proposed changes are the DOL proposed changes are changes to the salary requirement. There haven't been any proposed changes to the duties requirement, but just because they're going to be changing the salary requirement doesn't mean you still don't have to meet the duties requirement. So it's important to remember, even if they meet one, even if they meet the duties test, they also have to meet the salary test. So one area where I've seen that some of my clients get a little tripped up is they think that if they pay their employees on a salary basis that they're automatically exempt from the Fair Labor Standards Act and they don't have to pay them overtime. Unfortunately, that's not the case. If they don't also meet the duties test, then what's going to happen is you have to pay that employee overtime. Okay. All right, so let's talk about, now we're just going to talk about the salaries test. We're going to get to the duties test. This is a salary test for all the white-collar exemptions. So what, under the current requirements of the regulations, what's required? The employee has to be paid $455 a week. The employee has to be paid on a salary basis, and that means the employee regularly receives each pay period, a weekly or on a less frequent basis, a certain fixed amount. So it can't vary from week to week. To meet the salary test, the pay also can't be reduced because of the amount of work performed or the quality. So again, it's got to be that same fixed amount. Sure.
Hold on. Just one comment, one question. First off, I meant to say this earlier. Because of the large content material, if you have a really burning question or there's a critical point that's unclear, do raise your hand, but wait for the mic to ask. Otherwise, though, if you can hold other questions to the end, otherwise we won't even have any shot at getting through this. And those of you in the webinar, just pose your questions to me using the chat feature on the software.
I just want to confirm, this is for full-time employees. So if someone is, if they're working part-time, do you just do a ratio of that?
Prorated,
okay.
Yeah. Yes, exactly. Okay. And then the last requirement with regard to the salary test is if the employee is ready, willing, and able to work, the deductions to the pay can't be made if, deduction, you can't deduct from their pay if you don't have any work for them to do. You still have to pay them. Okay, so this is where the change comes in. So the proposed change is you have to be paid under the new regs, proposed regs, you have to be paid at least $970 per week or $50,440 per year. Okay, now we've talked about the salary test, which is going to have all those changes. Now let's talk about the duties test, which the employee also has to meet to qualify for the exemption. So when you're looking at the duties test to determine whether an employee can be classified as exempt, you have to take a look at the employee's, quote, primary duty. Now what's the primary duty? Well, the DOL very helpfully has told us it's their principal duty, it's their main duty, it's the major duty. I don't think that provides much guidance for us. So what you need to do is when you're trying to figure out what the employee's primary duty is, you're going to look at how important are the exempt duties that the employee is performing, how important are they compared to the other job duties. The more important they are, the more likely it's going to be their primary duty. The amount of time the employee spends performing their exempt duties. Now, an employee doesn't have to spend more than half their time performing the exempt duties, but the regulations do say the amount of time an employee spends performing their exempt work is helpful in determining their primary duty. You're also going to want to look at when they're performing their primary duty, are they allowed to do it free from supervision and direction? The less supervision, the better, right? You also want to look at the amount of wages that exempt employee is being paid to perform that work as compared to non-exempt employees. And what you typically want to see is that exempt work, they're being paid at a much higher rate than an employee performing non-exempt work. Okay, so the duties test and the proposed regulations. As I had mentioned earlier, there are no proposed changes in the DOL regs. However, they do request comments, and they request comments on very specific areas. First they ask, should we change the duties test at all? They also say, when we're looking at should there be a minimum amount of time an employee spends performing their primary duty? And if so, what should it be? And along those lines, they've also said, should we use California's 50% threshold as the model? So basically what that means, in California, an employee's time has to be spent 50% of the employee's time spent on their primary duty must be at least 50%. So the DOL basically saying, listen, when we're looking at the primary duty, do we have to require that employee be performing their primary duty at least 50%? The DOL also requested comments on when they should go back to the short and long duties test. And that's back in 2004. And basically what that was the lower salaried employees were subject to a longer duties test before they could meet the exemption. But the higher salaried employees were subject to a shorter test. And so the DOL wants to know if we should go back to that. So what do we want to know? We want to know, does the fact that the DOL hasn't proposed any specific changes in the regs to the duties test, what does this mean? Does it mean that there are going to be no changes? Not necessarily, unfortunately. Because they've requested comments, several people feel that this is an indication that in the final rule we actually may see some changes to the duties test in the final rule. Okay, so let's talk a little bit about the exemptions.
Jennifer, before we get into that, we had a question from the webinar, which is a good one, and that is, it really gets back to the salary test issue. If under the existing salary test, or even if it gets doubled under the new salary test, if an employee does not, say right now they're currently getting paid $30,000 a year, and let's say the new rules take effect and they're obviously not making $50,000+ a year, so they're no longer eligible for the exemption regardless of whether they meet one of these duties tests. The questioner asked, in that situation, does that employee then have to be switched to becoming an hourly employee? Do they have to be paid on an hourly basis, or can they still get paid on a salaried basis? And Todd, feel free to jump in too.
Yeah, go ahead.
The you don't have to pay on an hourly basis for a non-exempt employee. There's all different methodologies to pay them. The key factor is overtime. Okay, as long as they're getting minimum wage for every hour worked and an overtime at time and a half their regular rate for hours worked in excess of 40 in a work week, you're okay. Some employer, and this is federal law, some employers actually pay what's called a fluctuating work week salary, where they pay the employee a fixed salary every week for variable hours per week, and then overtime is paid at halftime. Okay, it gets complicated because the regular hourly rate was considered embedded within the salary. Okay, so the short answer is no, you do not need to pay them an hourly, but you need to keep your eye on that overtime ball.
So you don't have to pay them on an hourly basis, but you absolutely have to track their hours and,
yes.
and pay them a time and a half for all hours worked over 40 in a given week.
Yes.
Yeah. Okay, thank you.
Okay, so let's talk a little bit about the executive exemption. So we're just going to talk about the duties test because the salary test is the same for all the white-collar exemptions. So with regard to the duties test for the executive exemption, the primary duty has to be it has a couple of components. They have to be, the primary duty must be the management of an enterprise or a department of the enterprise. The employee has to regularly direct the work of 2 or more employees, and the employee also must have the authority to hire or fire employees, or in the alternative, higher management needs to take their recommendations into effect. So the DOL also actually requested comments specifically about this exemption. So under the current regulations, the DOL is concerned that too many employees are performing non-exempt work and getting swept into this executive exemption. And how is that happening? This is an example for you. So think about an assistant manager at a food establishment or a retail establishment. Their primary duty is managing employees or supervising employees. They meet all these other criteria, but what are they spending most of their time doing? They're doing non-exempt work, right? They're maybe cooking food, they may be cleaning, they may be stocking shelves. So the DOL has requested comments on whether too many non-exempt employees are getting swept into this category. So stay tuned and see what happens on that. So the next slide, I'm sorry, I'm a little behind. Okay. Right. Okay. I missed one. Okay. Okay. Yeah. Thank you. Okay. So when we're talking about the employee's primary duty being management, the DOL considers management to be, I've got it listed, I won't go through all of them. It's interviewing and selecting and training employees, conducting employee reviews, and you can see and kind of go through your own time. I'm a little short on time, so I'll keep moving along there. And then with regard, and this part is important, with regard to supervising those employees, the employee has to supervise the employees on a regular basis, right? It can't be that employee who is filling in for a manager when he or she is on a leave of absence or something like that. That's not going to count. It has to be regularly and customarily. And those 2 subordinate employees need to be full-time, or in the alternatively, they have to be part-time employees who are working a combined 80 hours per week.
Sorry to interrupt. Someone had a question about, and I know this is typical in the nonprofit world, what if our standard work week is 37.5 hours? Does that change the analysis at all? And I presume the short answer is no, it doesn't change anything. I guess it gives you a little bit of cushion if someone wants to work 2.5 extra hours and non-exempt employee without having to pay them overtime. But it otherwise wouldn't change the analysis. We also had a question about, and we didn't cover this in the beginning, do we have any indication when DOL is planning on finalizing these rules, when they might take effect?
Yes, we actually have some good news on that front. We thought the regulations were going to be implemented at the end of this year or early next year. The Solicitor of Labor announced last week in an ABA meeting that these regs probably will not go into effect until the end of 2016. So this is great news because it gives us time. We can evaluate, we can look at our classifications, and we can take all this information in and consider our options before it it jumps upon us, right?
Well, Jennifer, not to sound like a naysayer or to scare people, but when I read that, my initial reaction was, oh, that's good, it's going to be delayed. But then I'm thinking, they've got something up their sleeve, okay? And what I think they have up their sleeve is a high potential that they are going to throw in some modification of the duties test, because why do you need a full year to decide whether or not we're going to go from 23,000 to 50,000? You don't. You can do that in a day. So there's something maniacal going on with the analysis. So it makes it even more important to start looking at the duties test. So if that does come out, you've got to step ahead of the game.
I'll give you an answer as to why you need an entire year to double the salary requirement, because you're the Department of Labor, right? You're just kind of pedaling along. But yes, I think that's true. I mean, there is a very real possibility that they are taking their time to make those changes to the duties test, and a lot of employers are going to be surprised by those duties because we just don't have a whole lot of insight as to what those changes are going to be. Okay, so let's go. So let's see, how much time do I have? All right, let's move on to the administrative exemption. This is one that I spend a lot of time talking to my clients about. This is a real tough one. It's a catch-all a lot of times, I think, that employees get put into. So let's talk about the duties test a little bit and then break it down. So the duties test requires the primary duty to be the performance of office or non-manual work that's directly related to the management or general business operations of the employer or customers or clients. Now, this is an important one, right? The primary duty has to require the exercise of discretion and independent judgment with respect to matters of significance. And I'm going to move forward a little bit on that one. I'm going to skip that, and I'm going to get to the exercise of discretion and judgment. So I think that this one is really a tough area to navigate. And it's because arguably every job requires some exercise of discretion and independent judgment. And what's considered discretion and independent judgment to you and I isn't necessarily what the Department of Labor decides that independent judgment is. So when you're trying to decide whether somebody's exercising discretion and independent judgment, you want to take a look at, is the employee making actual choice between two courses of conduct? Are they free from immediate direction and supervision? Are they making these choices on their own? And it's okay if their decision is reviewed from time to time, so they can be recommendations, but you have to be careful that they're not just following established procedures, because the DOL says if they're following established procedures or manuals to arrive at an answer for an inquiry or a certain set of circumstances, that is not exercising discretion and independent judgment. And Todd, I don't know if you have some additional thoughts on that, because that's just one area I see a lot of clients struggling with.
Yeah, and when we get to some later slides on job descriptions and the importance in this analysis, it's where it really becomes important, because you will, when you analyze them, you'll be looking at not just the words on the paper, but how those words fit into these different criteria, both with respect to the frequency of the exercise of the judgment, but also with regard to how much the supervisor really oversees. Because a lot of times supervisors want their subordinates to be exempt because they don't have overtime, and therefore it minimizes the budget. So you have to sometimes push back on the supervisor, assuming that they are, kind of forcing a square peg in a round hole. So a lot of times it's watching and seeing and talking to the person who is supposedly exempt.
Okay, great. So we'll continue on. And again, I'm running short on time, so I apologize for skipping some of these slides. And just remember, everybody's got to meet the salary test in addition to the duties test. Okay, so the professional exemption, I'll briefly touch on this one. This one's a little more clear-cut, I think. So the primary duty of the employees must have to be performing work that requires knowledge of an advanced type or field of science or learning, customarily acquired by a prolonged course of specialized intellectual instruction. Now that's a mouthful. That's known as a learned professional exemption. This category also includes work that's being performed that requires invention, imagination, originality, and that's the creative professional exemption. These folks also need to be paid on a salary basis to meet the exemption. So the professional exemption includes a lot of several categories. It's usually, I want to point out on the slide, it's usually acquired through prolonged specialized study, but it can also be a combination of specialized instruction and work experience too. So it doesn't necessarily have to be that they study for an extended period of time. Common examples there: doctors, lawyers, pharmacists, RNs, and the like. Okay, I'm going to skip over this. Okay, so the computer professional exemption, this is another area. Again, those are the primary duty requirements. It has to be one of these, the application or the design of the system analysis and techniques, or it can be a combination of any of these, as long as the duty level is the same. The one thing I just want to point out is if you have an IT department, don't automatically assume that everybody in the IT department is necessarily going to fall under this computer professional exemption. You really have to go through and analyze whether their duties involve these specific areas. So somebody who's repairing computer hardware is not going to fall under this exemption, or even somebody whose work involves computers but doesn't involve like system analysis and applications is not going to fall under this exemption.
Jennifer, before you go on, we had a couple questions, and we get these all the time about the learned professional exemption. Had a few people say, we gave a list of examples, and of course that's always a dangerous thing to do, because now people said, are teachers included in the category? Are therapists included in the category? Are social workers included in the category? Any way to address that question kind of in a more general way to explain the types of learned professionals who generally can be deemed to be covered by that exemption versus those who are not?
I mean, really it comes down, I think, from my perspective, to a phone call. And I mean, this is such a specialized area, so you would really need to figure out exactly what the course of study was, exactly what their duties are. If they're not a professional, they could always fall under the administrative exemption. Todd, I don't know if you had any other general thoughts.
Yeah, that's right. It's generally dangerous to use a label and make the analysis based on that, because a lot of times you can have a label that sounds, of course that's a professional, but in the day-to-day and week-to-week job duties, it does not doesn't qualify as having the background, educational background, and in practice they don't utilize it.
So the educational background and training isn't determinative in and of itself. There could be someone who went to law school and then wisely decided not to practice law and is doing something else at a charity down the street, not practicing law, and they would probably not qualify. I mean, depending on the nature of the duties, they very well might not qualify for this.
Exactly. Having a law degree and actually working as a lawyer is not enough if you are, running and giving, just doing really mundane work. It may not be enough.
Okay, thanks.
Okay. I'm going to quickly move on here, but I do want to point out the one thing about the computer professional exemption. This is a little different with regard to compensation. You can go ahead and pay these folks $455 per week, or you can also pay them on an hourly basis. So this differs from all the other white-collar exemptions. They have to be paid at a rate of $27.63 an hour. Okay. And the highly compensated employee, we touched on that earlier with regard to the change in the threshold. Okay, so let's talk a little bit about next steps. Okay, so in light of these proposed regulations, you're telling me, okay, Jennifer, you told me what the regulations are proposing, now what are we going to do? Okay, so this is a really great time to look at your existing classifications. Take a look at your exempt and non-exempt employees. See if they meet the current regulations. Then start thinking maybe about if these new regs come into effect, how are we going to handle it? There's a couple ways you can do that. You could reclassify all your current non-exempt employees that don't meet the salary requirement and make them non-exempt and pay them overtime. You could also try to increase the salary of all those non-exempt employees so they continue to meet the new threshold, as well as the automatic updates, although that does run you into certain areas of concern, because if you have to continue doing that, you might create disparity between protected categories under the Title VII. So the silver lining. We talked about time. Okay, Todd was the pessimist and said, well, they're going to change the duties test, so it's no good anyway. But we do have a little time. You have time to look at your classifications. You have time to think about various options when the new regs do come into effect. So, and the other thing that I wanted to point out, I really think that when the final rules come out, this is a great opportunity to reclassify those folks maybe that should have been reclassified before. It's a great reason to say we have to do this. The Department of Labor is telling us to do this. I hear from a lot of my clients, well, you know, my exempt employees don't want to be paid, you know, as non-exempt. They don't want to make overtime. They don't want to be paid on an hourly basis because they feel less valued. This is a great way to say, hey, this isn't our decision. It's not that we don't value you. It's the government.
Okay. It's a great suggestion. We come in all the time, particularly when we're working with a new client. And Jennifer, you know, we've come in and done quite a number of kind of legal audits of new nonprofit clients of ours. And when we address the HR and employment areas and we get into this classification issue, there's such sensitivity. And employees really do feel degraded when they go from exempt to non-exempt status. It's not just the fact that they're non-exempt and the fact that they're getting paid overtime. All of a sudden now their hours are being strictly tracked, as you're going to hear about it, and a little bit strictly regulated about when they can work, often even where they can work. A lot of our nonprofit clients do not allow non-exempt employees to work from home, to work remotely, because of the challenges of trying to avoid people from working unwanted hours. And so this is a great excuse. I hate to use that word, but it is a great excuse to do that sort of reclassification under perhaps a little bit softer light.
Absolutely. Okay. Now we don't have a whole lot of time because Todd's got to get up here. But I want to talk briefly about a subject near and dear to my heart. I love independent contractors and the classification of independent contractors. So, as if we weren't reeling enough from the proposed regulations, on July 15th of this year, the DOL issues this administrator's interpretation of how to classify individuals as independent contractors. Now let me tell you, this guidance that has come out gives you very limited circumstances under which an individual should be classified as an independent contractor. And here's a direct quote from the guidance. Most workers are employees under the Fair Labor Standards Act. The ultimate inquiry is whether the worker is dependent on the employer or whether he or she is truly in business for themselves. Then the DOL went on to talk about the proper test to determine this classification. It's okay, and this is an important part I wanted to point out because I hear this all the time. You know, my client says to me, but you know what, this individual doesn't want to be an employee. They want to be an independent contractor. I'm sorry, but the Department of Labor doesn't care. The desire or intention of the parties is irrelevant to the determination of the classification. It's really important to remember. The DOL doesn't look at that. And here's the direct quote. It's not indicative and it is not relevant to the analysis of the worker status. So please keep that in mind.
Yeah, if the employee says, I don't care about health insurance and retirement benefits, and I don't care about you paying the employer share of the payroll taxes. I'll pay for all of that myself. I just want to be able to move out to Denver, Colorado, and work from home and do the same work for you, compensated as an independent contractor. If it's otherwise the same working relationship, and that's the only organization that they're working for, they're almost certainly not going to qualify as an independent contractor.
It's really tough under this new guidance to classify somebody as an independent contractor. So what the Department of Labor has said in this guidance, they want you to use, they kind of cherry-picked from all the case law that's out there. They focused on the test that is most beneficial to their position, and that is they want you to look at the economic realities test. And let's see, I'm going to skip that. Oh, okay, I'm going to start talking even.
And Jennifer, before you get into that too far, we had a question from the webinar about how does the DOL's rules and interpretation of employees versus independent contractors kind of jive with the IRS's interpretation. And of course, there are, as we know, very important consequences and implications both for DOL purposes in terms of classification and the consequences of improper classification, and there also are tax consequences. If you're not paying the employer share of payroll taxes because you're improperly classifying someone as an independent contractor, then they get classified as an employer. All of a sudden, you're stuck with a pretty big tax bill, plus potentially interest and penalties. But beyond that, how do the two federal agencies' kind of interpretations of the rules in this area, how do they come together?
There is a work share agreement between the DOL and the IRS with regard to this issue, but they really are enforcing separate statutes. So you have to go down the lane of the DOL, and then you also have the IRS to contend with. Fortunately, I did just forward it because I'm kind of running out of time here. The DOL has a three-pronged test. They focus on the control. You can go back to your slides there. It's the behavioral element, the financial, and then the type of relationship. And it's very similar to this economic realities test. You'll see a lot of overlaps that the DOL is using. But yes, you do have to contend with both, and you could be subject to liability under both statutes. So this is the six-part economic realities test that the Department of Labor is saying is the way to determine whether an individual should be classified as an employee or independent contractor. It's just good to remember that not one factor is just positive. You have to look at the whole situation. So just because you're not exerting control over the individual, that doesn't mean they're necessarily going to be an independent contractor. You still have to look at these other elements, and I really am running out of time, but I wanted to.
Yeah, and by the way, we did a whole 90-minute program on this topic of employees versus independent contractors probably 2 years ago. So if you want to see more about that, just find our recorded webinars on our YouTube channel, and you can listen to that program.
But I did want to point out, why do we care about this? We should care about it. It's concerning. The consequences of misclassification can be very, very costly. If you're found to have misclassified somebody as an independent contractor when they should have been an employee, you're going to be responsible for income tax liability for monies that you should have been withholding from their wages. You're going to be responsible for Social Security and unemployment taxes. If the individual was working more than 40 hours a week, you may be liable for overtime pay and other wage state claims. You've got your state unemployment insurance payments that you're going to be responsible, workers' comp, and also because the individual should have been classified as an employee, they should have been entitled to various benefits. So do I have any good news? We'll see. The good news is this is just an administrative opinion. So the good news is this isn't going to have, it's not like it's probably an interpretive rule, and it's not going to carry the force and effect of law. So this is different than the regulations. So it's not necessarily, most likely not going to be binding on you. So you'd say, oh great, I don't have to worry about this at all. I'm going to drop it in the trash. I'm going to drop this part of the presentation out. No, we need to care, and here's why. Because this gives us really great insight to how the DOL is going to approach independent contractors if you're audited. So if by chance one of your employees goes and complains to the Department of Labor and says, oh, I think I misclassified, I think I was paid, I should be paid overtime, the DOL is going to come in. And they're not just going to ask for your time records, and they're not going to just ask for your pay stubs. They're going to ask for everything. They're going to look at all your pay policies, and they're going to ask for all your independent contractor agreements. So again, we have time. I really believe that this is a warning that the DOL has sent out to the community saying, we've hired a lot more auditors, and we're going to get out there. So try to get your ducks in a row before we get there. So again, this is a great time to look at your classifications and examine what you've identified as independent contractor relationships in light of this new guidance.
And just like Jennifer said on the DOL, they get a complaint, they come into your organization, they're not just going to look at that particular employee's issues. They're going to look more broadly at all of your employees' issues, and like she said, they're going to look at lots of other issues as well. We see the same exact thing with IRS audits, whether it starts by a focus on some exempt status issue or an unrelated business income issue or an executive comp or private benefit issue, and then it spreads to other things, including payroll tax issues and independent contractors. We see that all of the time. And remember, the consequences consequences here are not just enforcement from federal agencies like the U.S. Department of Labor and the Internal Revenue Service. It's also state departments of labor, and then it's the private right of action, the fact that individual employees can bring claims in court through federal and state agencies, and as Todd mentioned earlier, the threat of potential class action suits, which we see all of the time in this area, is really particularly dangerous. Before we move on to Todd, one threshold issue that we should address, maybe not as much for the participants in today's audience, but for their, for instance, state and local chapters. We had this question from the webinar. Is there a threshold issue about when the FLSA even applies to an organization? Most of the participants in today's program are national organizations that operate on a nationwide basis. They may be physically located in one state, but they're operating nationwide. But is there some threshold issue of whether the FLSA applies at all? Does it apply to all employers? Is there a threshold in terms of the number of employees? Do you want to speak to that, Todd or Jennifer?
Yeah.
Yes.
If you have one or more employees, you're going to be covered numerically. There is an enterprise limit. In order to be covered in an enterprise under the federal law, you need about $500,000 worth of business. Okay, and for nonprofits, that can be a potential get-out-of-jail-free card for coverage as an enterprise, depending upon the nature of the money in and money out. Okay, so if you are in a situation where you're thinking, hey, we may be exempt from this, it's worth a look. But remember, the large print giveth and the small print taketh away. It doesn't mean you're not regulated in the wage and hour area, because states in almost every circumstance are going to have a similar wage and hour law that is going to apply to you, and it may be differing depending on where your employees are located.
Okay, thank you. One question here, and then we're going to move on to the next part.
Okay, we said all these terrible things can happen if it's found out that you're doing it wrong. We also said, you might want to fess up, and if you find out you're doing it wrong, you might want to fess up and change people. Do you have to do anything retroactive? I mean, if you do this analysis yourself, aren't you opening yourself up to an awful lot?
You are, yeah, you are. I mean, as Todd had mentioned earlier, the liability for the misclassification, the damages can go back 2 years, and can go back 3 years in cases of willful negligence. So if you want to make it right, you would go back and try to calculate the employee's overtime in the past 2 years, and then pay the employee for that time. That is something that is a very, very delicate process, and before you do it, we highly recommend that you give us a call so we can guide you through that process, because the last thing we want to do is raise more red flags and more issues.
Yeah, and what Jennifer talked about would be the most conservative approach. That's not the approach that most of our clients typically take, because A, they don't want to pay that amount, and B, they don't want to open up a Pandora's box of potential lawsuits and claims and whatnot. But it is a very delicate balancing test, and you have to, every situation is a case-by-case basis, and how you execute this, how you implement it, how you roll it out, how you talk to your employees about it, how you maybe sweeten the pot, all of this has an impact on how successful or not you're going to be in that process. All right, Todd.
Okay, I'm going to change gears a little bit and talk about written job descriptions and the importance for your nonprofit. Now, in my world, I've got a list of top 10 and top 5 best practices, and one of my top 5 best practices is having accurate written job descriptions for every position. Now, the focus today is on the benefits in the wage and hour area, but there are also benefits you can have in other human resources activities that support good job descriptions. They can be used as an important tool for employee selection. Okay, you can use them to create interview questions. They're good for employee evaluations. They're helpful for compensation analysis, both internally and externally. They are critical for the ADA, the Americans with Disabilities Act accommodation process, because the EEOC and other government entities take the position that if there's a dispute about what are the essential functions of the job, a pre-existing job description can trump everything. And they also have some benefit for FMLA compliance. But in the wage and hour context, The primary benefit of having a good inventory of job descriptions deals with being able to audit your workforce for proper classification, okay, determining whether they are exempt or non-exempt. So if you have a robust, accurate job description and an organizational chart and some compensation information, that gets us to the 90-yard line in most cases of what we need to look at to see whether it's properly classified as exempt or non-exempt. In other words, a good job description provides you with a roadmap of all the variables that Jennifer was telling us about. A second benefit is it is very helpful if you are actually sued for a wage and hour violation or threatened with a lawsuit. Many times when you are fighting with employees who are suing you over classification issues, they try to say, well, gee, I really didn't do anything important, because they want to be non-exempt so they can get overtime. So they say, yeah, I didn't really do anything. I didn't exercise independence or importance. They really try to downplay what they did, and the employer, on the other hand, tries to elevate what they did as super important, and sometimes you get just contradictory information. So if you have a job description that sets forth what their duties and responsibilities are, that's pretty important. And another little caveat is, in the rock, paper, scissors battle in employee relations, documents always beat testimony, okay? So if you have records showing what the employee does, the jury can take it back in the jury room, look at it, see it, read it, taste it, feel it, and they're going to remember that and probably give it more credibility over an employee who testified, nah, I never really did stuff. So it has a lot of benefits. Another benefit has to do with good faith. We talked about the huge damages that can follow a nonprofit in this area if you get hit with a class action. If you have a good faith defense, it, number one, sometimes can stop the doubling of damages, and number two, it result in a shorter limitations period. And having a good job description that has been vetted with counsel can help you assert that defense. Okay, the content of a job description, it's fairly straightforward. You've seen them all. And one thing I have to tell you is putting together a hastily cobbled job description that's not really accurate is worse than not having one at all. So take your time and do it properly. And this slide shows you what are the typical content that you have in a job description. You need to tailor it for a job because not all are going to have, for example, physical requirements. But this sets forth what you would generally see in most cases. Okay. Sure. Okay, so how do you prepare or review and revise job descriptions? Okay, it ultimately involves collecting information and determining the functions and requirements of the job. And the primary methods that we like to see are starting out with a template of structured questions to be answered to help determine what are the key job functions and responsibilities. You can also get access to samples used by other employers and other nonprofits for similar jobs to look as a basis. You can have the person in the job keep a log of their activities over a period of time, weeks or months, to be able to discern what they're doing and how frequently. This isn't really popular, but you can also review their email over a period of time to see what they're doing on a day-to-day basis, with whom they're interacting, and what type of decisions they're making. You can observe the employee do the job. Just actually watch them for a period of time. Most of the times a supervisor can do that for you to see what they do. The last way is it's actually hiring an expert, called an IO, an industrial and organizational psychologist, who will do everything I said and more, and conduct what's called a job analysis that will be very strong, and you will not only get a job description out of it, but you'll also probably get interview tools, evaluation tools, and things of that nature. You also want to make sure that you periodically review job descriptions. Many jobs, most jobs, are subject to change over time due to personal growth of the person in the job, organizational changes, evolution of new technologies. Sometimes you have someone in a job and they stop doing certain jobs, duties, and they get others. And the job descriptions oftentimes just sit on a shelf for years and years and don't keep up with these changes. So a periodic review of every year or so is a good practice to do.
And Todd, I'm presuming that this is something that we typically don't see our clients doing. Typically, you have a job description. Once that job gets filled, that's it. You don't revisit it until it's time that person leaves and you're ready to refill that position again. And I know from our end, when we go in to do, say, a legal audit of an organization on the HR front, one of the first things that Jennifer and Todd always ask for is, let's see your written job descriptions for purposes of FLSA analysis and other things as well. So this is really an important practice that, in our experience, most organizations don't do. But it is particularly important, I would say, especially for those employees that are either non-exempt or exempt, but perhaps on the cusp of, exempt versus non-exempt for this purpose. And then for many other purposes, as you said, there are many other important purposes for keeping those up to date.
Yeah, it's exactly right, because I can tell you the last 3 times I've looked at job descriptions in the last month, all have been situations where the person in the position said, why am I not getting overtime? Okay. So they go to the HR pulls the job description, and in many cases, in fact I would say in the last 3 cases, the job description did not match what they were doing because it was just either pulled off the internet and thrown in their file, or assembled years ago without regard to the changes in the job or changes in technology. So it's a dull process. I get it. It's not something that's going to be fun to do, but it is a huge lifesaver if you get hit with a lawsuit or want to conduct a wage and hour law or a wage and hour audit. And as Jennifer pointed out, if these regulations kick in their present form, this salary basis is going to escalate every year. So what for the exempt, non-exempt breakout. So that means every year you're going to have a new group of employees on the bubble, okay, the jobs around that pay level. And those are the jobs that have the most risk for nonprofit for real money. Because if you're at that level and you guess wrong and they're working overtime, that is a huge, huge amount of liability. So that's why regular review, at least for folks in that salary bubble, is a good risk avoidance practice.
And Todd, if I can jump in real quick, I echo what Todd says. A yearly basis is great. In fact, one of my clients does it along with the performance evaluation. It makes it very natural, and it's something you can get in the habit, and it becomes a very real reflection of what the employee is doing as you're looking for their performance goals in the past year and the current year.
And question for you, would it be appropriate and or dangerous to ask the individual employees to take the first stab at updating their own job description?
That's a great question, and it depends on the employee. I would say if you have a top performer, okay, it'd be a lot easier. If you have a slacker, garbage in, garbage out type answer. So it's something to consider. There's a value actually from a litigation standpoint. About half my practice is litigation, representing companies who are alleged to have done bad things. And we find that having the employee either participate in the creation of the job description or involved in the review is helpful, because if they go into court and say, yeah, I really just, had menial chores, I didn't do anything important, but we have their signature that they agreed to the job description that shows important duties and responsibilities, they look a little shaky. So there is a value from a litigation standpoint of having employees at least sign off that yes, this is accurate. It's not a 100% win, but it's the kind of thing that makes our lives a little bit easier. All right, shifting gears a little bit to managing non-exempt overtime. I like lists, so I'm going to rattle through about 4 steps you can take to minimize the overtime, because what's going to happen with these new regs is you're going to have a lot of employees who all of a sudden are entitled to overtime. Okay, it's going to happen. So it's a good opportunity to kind of look at what we can do to make sure we don't get hit with unpaid overtime claims, because that's the big type of lawsuit we get. Now remember, in my earlier example, just 50 employees earning $50 an hour over 3 years can result in $750,000 up to $1 million in damages. So we're dealing with really real money. And these steps are not complicated. Number 1 is make sure you have in place a robust time and attendance tracking system. Okay. Once employees are considered non-exempt, you are obligated under state and federal law to record, you, not them, to record the number of hours they work on a day and week. There's no required methodology that you use, but there are so many tools out there that allow it to be kept electronically, and it just improves the accuracy and minimizes the chance of an unpaid overtime claim. Second, and as part of this, is I strongly recommend that employees who are non-exempt, whenever they sign off on a timesheet, either electronically or manually, they sign a certification that says, this is a complete and accurate reporting of all hours I worked. Okay? I certify, I swear it's true. The reason that's important is in many cases, when these turn into lawsuits, it's the employee's word against yours. And they're saying, yeah, my boss made me work off the clock and told me not to record it. But if they've signed a timesheet saying they promise it's accurate, it perhaps can be used to degrade their credibility a little bit and improve yours. So easy to do, and it's number 2. Number 3 is implementing, disseminating, and enforcing an overtime policy. Now this is going to really change depending on the nature of your organization, but most overtime policies say you can't work it without advanced written approval. You will be paid for all overtime even if it's unpaid in most cases, but you may be disciplined for working overtime without permission. All employees are encouraged to report violations. If your boss tells you go ahead and work these extra hours but don't report it because we're having budgetary issues, you want them to bring that to the attention of HR and higher-ups without retaliation. And then the 4th is management training. Okay, letting supervisors, you got to read them the Riot Act, that they are not permitted under any circumstances to allow non-exempt employees to work without pay, no matter what. Right? You really want to get their attention. Remind them that this law, the 77-year-old creepy bionic Frankenstein law, allows personal liability. It's them. Okay, they can be sued individually for unpaid overtime violations, and that usually causes them to toe the line.
Todd, before you move on to the next slide, and we did actually a whole monthly program on this topic of what is compensable time for non-exempt employees, and it's one of my favorite topics in the HR area. We could spend all day on it, but a couple kind of additional points to consider in terms of managing time. And this is so important because you are going to have so many more employees who are going to be considered non-exempt, and so you're going to have to deal with these issues. One is the concept of you are permitted to not only say to employees they can't work overtime without prior permission, but if you know, for instance, that a non-exempt employee is going to have to be working 40 hours over the first 3 days of a work week because they're at your annual conference or they're doing something else where they're working 12, 15-hour days, you are certainly permitted, and tell me if I'm wrong or if there's any nuances here that I'm missing, are you permitted to say, you have to take the rest of the week off? You cannot work the rest of the week because you've already hit your 40 hours in the week.
Yes.
Okay.
Yes, that can be done.
Similarly, just if someone works a long day, you have a big deadline, you have a big report that's due to your federal agency that you get your big money from, and you can force someone to come in, or say the employee has to go to a dinner the night before, you could say you cannot come in until 12 o'clock the following day. Things like that to regulate and manage time is certainly permissible, correct?
Yeah, permissible under the wage and hour laws. You may get some pushback under general employee relations type morale issues, but that's a little more subtle.
Similarly, in terms of employees working remotely, like I said earlier, some of our clients do not permit non-exempt employees to work remotely. They don't give them access to their network remotely. Others, though, do. And to me, it seems like there's more of a trend because everyone's doing it. You almost have to allow it in some instances to allow employees to work remotely, but it doesn't mean you can or should regulate their hours any less just because they're doing some work from home.
That's correct. That's correct. And that goes in the first one. That would be part of the time and attendance system. It would need to be focused on if you have remote folks or folks who telecommute to make sure that it applies to them equally, though they're not under your watchful eye.
Okay, one more question. So it's very common for nonprofits to utilize comp time, compensatory time for exempt employees. So the exempt employees are working night and day at the annual conference for 4 days in a row, and then you give them comp time to take the rest of the week off or to use some other time. And for truly exempt employees, there's no restriction or limitation on the use of comp time generally.
It's somewhat of it doesn't exist, okay? It's called that, we see it all the time, but for a private non-governmental employer, you don't use comp time. If you're dealing with exempt workers, they get paid the same amount during the week whether they work 10 hours, well, aside from certain deductions, but their salary doesn't change based on quantity or quality of work. So if they put in 60 hours one week and they want to, relax a little bit, that's fine. But that's technically not comp time. It's just being paid on a salary basis. When dealing with non-exempt employees, you cannot use comp time if you are a non-governmental private entity. Okay, it's one of those myths that we see over and over again. There is a very small loophole exception in the FLSA called paid time off plans, which permit you for a non-exempt employee who is paid biweekly or bi-monthly, this is a little complicated, and they work overtime the first week, they can have paid time off the following week in an amount that would be equivalent to what their overtime would be. Okay? Very few employers do it because it is hard to manage. It's really hard to administer, and if it gets forgotten and you have a manager who tries to run it on the fly, it never works, and you've got overtime issues.
Although we have seen some of our clients utilize that narrow exception around the big conferences or events like that, where you have to have your non-exempt employees there. You have to have them work a lot of hours. And basically the way that I think of it, if you can make the timing work, is that you're giving comp time at time and a half within the same pay period to compensate for those extra hours worked.
It's comp time. Again, it's terminology. Everyone calls it comp time, but technically it's comp time only is for the government. These are paid time off plans. And I think that example is one of the rarities where we see it. It's where you've got just a bustle of activity within a short period of time.
Okay, one more question for you, Todd. This comes up a lot. Dangers, and you referred to this earlier when we were talking about comp time and exempt employees, and you said really it doesn't exist. And part of the reason is you're not supposed to be tracking their hours. I mean, you can track them for other purposes. If you get federal money, you have to track their hours. So that's getting billed to the government. For lobbying purposes, for other purposes, you have to track time. But for purposes of how much they get paid, you're not supposed to be tracking their time and paying them on the basis of how much they get paid, of how many hours they work. But talk for a second about the dangers of, and I forget the phraseology that's used in this area, but basically of for instance, taking partial day pay deductions for people that are taking a half a day off. We're talking about exempt employees.
Sure. If you have an exempt employee who takes a half a day off for a doctor's appointment, and you say, well, we're not going to pay you for that half a day, what you've done is you have docked their pay based upon the quantity of work. Okay? And remember, being paid on a salary basis means you get the same amount each week without regard to quantity of work. So you have therefore converted them away from the salary basis test, and they are now arguably entitled to overtime. Okay, partial day deductions are not permitted under the FLSA. The Department of Labor has said, though, if you require them to use their leave bank, okay, like a PTO or sick for that doctor's appointment, so at the end of the week they get the same amount, you're okay. You haven't jeopardized the salary basis. You can even allow them to go negative on their leave bank to do so. But if they've exhausted their leave and they take a half day off, you can't deduct their pay. You can deal with it as a disciplinary, rules infraction performance, but not as a pay issue.
Excellent. That's exactly what I wanted you to talk about, the pay docking rule. That's what I always refer to it as. And it's something, there's a lot, I saw a bunch of people taking notes when Todd was just talking. There's a lot of noncompliance in this area. A lot of people don't realize this, but it's really dangerous. I mean, theoretically, even that one-time half-day pay deduction could convert someone to a non-exempt employee and subject you to all of this, mess of everything else we're talking about.
Overtime back for years. And there are some slides in Jennifer's deck that give you the 5 or 6 exceptions to the rule. Okay, I want to close on a real high point here because I've scared everyone. Just point out here the compensable time for non-exempt employees. This is a list of issues that we often see nonprofits that have to deal with in what's compensable or non-compensable. They're not common sense driven in many cases, and we'd be happy to chat with anyone either after this meeting or down the road if you have these issues, because you can really trip up, and these do generate a lot of work.
And Todd, if you can go back to that slide for a second, this is an important point. Even if you are not requiring an employee to be on call, to be ready to answer the phone, to be sitting at a post, to be waiting for an email at home. Certainly, if you are requiring them to do that, that's certainly compensable time, even if they're spending 99% of that time reading, a trash magazine. But if you even just allow them to do it, you're allowing them to for instance, to do work, to take lunch at their desk and work through their lunch break when you're presuming that you're not going to be paying them, but you're allowing them to do it anyway. You could be on the hook for having to pay them for that time, correct?
Yeah, you are responsible for overtime to all compensation if you know or should have known that the employee was working. And working doesn't necessarily mean being productive. It could be waiting for work. So there are a lot of do's and don'ts and tricks of the trade to deal with these issues. And part of it goes into what I want to close with is compliance tips and strategies. And the most prudent thing you can do to avoid these nightmare scenarios is conduct a wage and hour audit of your pay practices. You can't change the circumstances that's happened in the past, but you can reduce the risk of something bad happening in the future. Now, at the risk of sounding like I'm going door to door hawking steak knives, I can tell you that having an attorney involved in the process is important for 2 reasons. Number one is it allows you to have a real gritty evaluation of your practices without the outside world ever knowing, because you can put it in the envelope of the attorney-client privilege. Number 2, having an attorney involved in the review will go a long way establishing the good faith defense. Even if you're wrong, even if you decide wrong, if you've had an attorney help you, the courts will probably limit the damages and shorten the statute of limitations period. Okay, the steps you want to usually cover in an audit are reviewing exempt job classifications to see whether it's proper or improper. You want to look at the compensation arrangement, the duties test. You also want to look at that long list of, for non-exempt pay practices, whether employees are working or not. You want to look at your record keeping, your posters, your notices to employees, your independent contractor arrangements. These are all hot button items. Now, this is what I want to close with because it relates to what the gentleman said, and I get this a lot when clients come to me and say, well, now we know we have a problem, what do we do? Okay, two approaches. Number one is you just look forward. You reclassify folks, you change compensation, you change duties, you stop the bleeding. Okay, that's the easy answer, smart thing to do. But what do you do if you have a situation you realize, well, gee, we've got this person that's been worked in the IT department. It turns out they're not a computer professional. Do we pay them overtime? Do we go back 3 years? And it is a hard discussion to have, but it's worth having, okay? Because sometimes clients end up doing it, sometimes they don't. And those that haven't, I can tell you stories where nothing's ever happened. No lawsuit happened. But I can also tell you that they've made changes, and next thing you know, you get these attorney letters. Okay? But it's always better for you as a nonprofit to manage your own audit, to do it with the way you want it on your time frame with your tools and your talent. If, however, a lawsuit hits, you will be doing an audit, but it will be under the direction and supervision of a plaintiff's attorney, who you will probably end up having to pay for it. And they will be looking for more and more things to add to the lawsuit. So in closing, in general, the negative risks and consequences of doing an audit do exist, but it's a lot better to do it on your time frame, on your with your format, rather than at the point of a sword through an employee's lawyer. Okay.
All right, we have just a couple minutes left. Questions? Yeah, there's one in the back of them. Just wait for the mic if you could.
Yeah, just a question in terms of independent contractors. So the clawback period and all those sorts of rules and the penalties, are they the same as for misclassified employees?
Yes, because what happens is if you have someone who's an independent contractor, in air quotes here, but is not, that means they're really an employee. And what they're doing is saying, oh, by the way, I've been misclassified. I really am an employee. I've been working 10 hours of overtime for the last year. My regular rate is, I don't know, $50 an hour, so you owe me $75 an hour times 10 hours times 52 weeks. Oh, and by the way, I want all independent contractors to join me and that have worked for you for the past 3 years to sue you as well. That's the story we hear.
Todd and Jennifer, a question from the webinar. If an exempt employee is on vacation and takes paid time off for the vacation day but ends up doing some work during the day, should they not take, say, a full 8 hours of PTO for that day? Is there any risk in or restrictions on allowing them or not requiring them to take the full amount of PTO for that day?
It gets really tricky when you start pulling out an egg timer for exempt employees who perhaps are on vacation, okay, or want to take some time off. A lot of clients say, okay, we want you to take half a day off. Don't just take an hour off. Take a whole half day off so we can do big dockings from your PTO. And that's okay. You can, at least on the federal law level, some states have some nuances. But if you start saying, okay, well, gee, you were on vacation, you typically work 8 hours, but you were answering emails for 3, so we're going to pay you for 3 and then dock your PTO for 5. It really gets cumbersome. So you have to balance the employee's desire to be a good trooper, even if they're on vacation, with an even-handed administration of your PTO plan.
Now we have another question kind of the flip side. So a non-exempt employee that's over the weekend, for instance, checking on some work emails and sending a few responses. The questioner says, that seems like work that they should be paid for. Do we tell them not to read or respond to emails outside of work hours?
Yes, unless the time can be considered de minimis, then it wouldn't be compensable time. So if it's just a couple seconds here or a couple seconds there, but if it's substantial and they're sitting down and they're answering emails and phone calls and writing documents, unfortunately that's going to be considered time worked, and you're going to have to pay the employee in excess, if it's over 40 hours a week for that overtime. And so yes, the answer would be yes, definitely instruct your non-exempt employees that you need to get your job done between their regularly scheduled hours so they don't go over that 40 hours.
Unless they have written authorization to do that work. And presuming it could also be a very slippery slope. If you consider it de minimis, you let them do it here or there. They're keeping a tally of all their hours worked, and then you get hit with that claim later on. That could be dangerous. Okay, one final question here in the room, and then we need to wrap up.
On the slide that says compensable time for non-exempt employees, you list on-call time. Can you speak about on-call time and like if someone's on-call overnight or on-call on a weekend, is that something that you would have to have the comp time?
Sure. The general rule, if a non-exempt employee is on call off premises, they don't have to be paid for waiting to be called. There are variables that the courts consider that can move them over into the compensation area. It includes things of if they have a limit on their geographic straying, okay? If they're told you can't drink alcohol, if they're told you have to check in, every hour to let us know you're still there, if you have a 10-minute response time if you get called, things that restrict their freedom to enjoy their lives, the more there are, the more it looks like they are kind of like the receptionist sitting reading a book waiting for folks to come in. They really are working. So you want to minimize the chances of getting hit with on-call time is give them complete freedom to do whatever they want, but if they need to come in and do work, then you do it.
And I assume also the flip side, that receptionist who says, I'm going to stick around for an extra hour because I'm waiting for my husband to get off work and he's picking me up. That's a situation where you probably want to say, no, you either have to leave the office or go into the break room or do something where you're not allowed to work during that time.
Yes.
And then there's one final question, which I'm glad our questioner asked, and it's a really big one. You had a bullet point on your slide about this, Todd. Travel time for non-exempt employees. I always think the rules here are very interesting. Do you want to just in a minute or two kind of give a synopsis of what the rules are for what's compensable and what's not when it comes to travel time? Because that does happen quite often in the nonprofit world for non-exempt employees.
Here's the big picture, and they're very nuanced. Commuting to and from work, not compensable. Okay? If you have an employee who comes to work and part of their job involves traveling to clients or different sites during the day, that is compensable. If you have an employee who, for a particular day, drives out of town for one day outside their normal work, that travel time is compensable, but you can deduct from that their normal commuting time. Lastly is overnight travel. Overnight travel is compensable if the traveling, this is an odd rule, overlaps their regular work hours. So if an employee generally works 9 to 5 Monday through Friday, and they're traveling to a conference on Sunday, if they're flying, let's say from noon to 3, that's compensable because it crosses their normal work hours. But if they're traveling the red eye, midnight to 3 a.m., it's not because it doesn't cross over their normal work hours.
That was impressive. Less than 2 minutes, about 90 seconds. Very well done. And for the whole program, Todd and Jennifer, terrific job. Thank you so much. Thanks everyone for coming, and hope to see you back here next month.